Thank you. We're hearing our case 1CA-CV 160396, YODER versus TUX XPRESS. Each side will have 20 minutes for their argument. Appellant, you may reserve any portion of the time for rebuttal, but you must keep track of the time yourself with a clock at the podium for that purpose. We are recording this argument, so it will be on YouTube in a day or two. And because we're recording it, please identify your client and yourself when you begin your argument. We've read the record and the briefing, and we've conferenced the case, so we're familiar with the facts in the argument. So when you begin, just start with your argument, what you would like for us to consider. Counsel, you may begin.
Good morning, Your Honors. May it please the Court. My name is John Dillingham, and I represent the appellant, John Yoder, in this case. I'm going to focus the majority of my argument on explaining why the trial court erred in concluding that TUX XPRESS owed no duty to its business invitee, Mr. Yoder, in connection with the April 26, 2013 accident, which occurred directly in front of the TUX XPRESS suite and which was regularly used by TUX XPRESS customers as a means of ingress and egress.
Yeah, so when you say directly in front, do you mean on the sidewalk or on the
It was in the common area, Your Honor. There was the storefront, then there was a sidewalk, and then there was a common area, which consisted of gravel and the bricks are what collapsed and caused Mr. Yoder to fall.
And if it's a common area, then what responsibility does TUX XPRESS have for the area then?
That's a good question, Your Honor, because that sort of highlights the distinction between the existence of a duty and the breach of the duty. Ever since the 1986 Arizona Supreme Court decision in Markowitz, Arizona law has been clear that a duty is established by the relationship of the parties. And in this case, it's undisputed that the relationship of the parties was a business owner and business invitee.
And just I don't want to throw you off your argument, but you started by talking about ingress and egress. I want to make sure I understand. The ingress you're talking about is from some parking area to the sidewalk. It's not the ingress from the sidewalk into the business.
Well, as you can see, I'm sure you looked at the CD that we sent, which shows that typically when customers parked in front of TUX XPRESS, they would transit directly over the common area and then take a step or two across the sidewalk directly into the TUX XPRESS store. And ever since, for a number of years, ever since the Stevens decision and the Udy decision and the Timmons decision, Arizona has recognized that the duty extends beyond the geographical boundaries of a premises. And in this particular case, it's undisputed that Mr. Yoder was the invitee of TUX XPRESS at the time of the accident, and as such, under Markowitz, Stevens, Udy, and Timmons, TUX XPRESS owed a duty to provide a reasonably safe means of ingress and egress.
But it seems to me that there was a marked ingress and egress to the sidewalk and to the entrance to TUX XPRESS, but your client ignored that and walked across the common area. I'm sure that there was a quicker way to get to the store, but that wasn't the path that people were supposed to take.
What Your Honor has just stated highlights the distinction between the existence of a duty in the first place and whether or not there's a breach of the duty. Certainly, if TUX XPRESS were to argue that there was an alternative means, that would be relevant to whether there was a breach of the duty, but not to whether the duty exists in the first instance. And that's the only issue upon which the trial court granted TUX XPRESS motion for summary judgment. It never got to the issue of whether there was a breach. So what Your Honor has just mentioned would certainly be a factor that would be relevant to whether or not TUX Express breached the duty, but not whether the duty exists in the first place.
But before we get to the issue of the breach of a duty, there has to be a duty, and if TUX Express had no control over the area where the accident occurred, is there a duty apart from whether there's a breach of that duty?
Yes, and that is clear in both in the Stevens case and in the Udy case, and then in the Timmons case. Control is simply a factor to be considered as to whether there's a breach. I think the best way for me to underscore that point is to actually, and so I don't have a senior moment, I'm just going to read the actual language from the opinion. It's the Udy decision at page 11. And this is exactly what the court said. This division said, the landlord reasons that because the relationship in this case is that of landlord and tenant, and because the landlord-tenant relationship is limited to the boundaries of the leased premises, a landlord has no duty to protect the tenant from dangers located outside the premises. And it cites some cases, and it concludes with this. None of those cases held that the geographic limits associated with a particular relationship necessarily delimit the scope of any duty of care imposed upon the parties to the relationship. So, Judge Howe, your point is absolutely well taken in terms of the availability of the sidewalk as it relates to whether there was a breach, but not to whether there was a duty in the first instance. And as I pointed out in my reply brief, and as we pointed out in the motion for reconsideration, there are a number of things that were available to TUX Express that it could have done that wouldn't have required it to step 1 foot outside its premises to potentially discharge the duty. I mentioned the fact that it could have given written warnings inside the store. It could have given verbal warnings. It could have contacted the landlord to insist that the landlord take appropriate steps to fix the risk, but they didn't do any of that. All of those factors are relevant to the breach issue, not necessarily pertinent to whether the duty exists in the first place. I want to mention the 3 cases that TUX Express cites in its answering brief and show why they're not controlling in this case. The 3 cases were the Kaiser case, the Clark case, and the Timmons case. The Kaiser case was a 1969 decision, 15 years before Markowitz, and that case was decided on the basis that the defendant failed, or the plaintiff failed to contradict the defendant's facts in a motion for summary judgment, and the well-known principle that the mere fact that an accident occurs is not proof of negligence. In Clark, and this is the more challenging one, the court relied upon Markowitz and based the duty analysis on the relationship between the plaintiff and the defendant. The court ultimately ruled that the district had no duty because the district had a limited right to use the property, and the injury caused by the cable fence was unrelated to that use. But in this case, the common area is regularly used by TUX Express customers as a means of ingress and egress, and thus was squarely within the scope of TUX Express business purposes, which is identical to the situation presented to the court in the Timmons case, where the appellate court found defendant's easement was for the very purpose of entering and departing the business, which is exactly how the plaintiff was injured in that case and how the plaintiff was injured in this case.
But in that case, there was an easement which gave a measure of control to the store, and that isn't what we have here.
That's not the basis upon which the court made the analysis, because the injury-producing piece of equipment was a cable line. The easement gave the district no power to control the cable line.
Well, if the easement didn't matter, then why was the easement discussed at all?
I have no idea why the counsel in those cases chose to make the arguments they did. All I know is that the court was very clear that because the district's use of the property was unrelated to the cable, and because the plaintiff's injury was unrelated to the defendant's use, that there was no duty. But that's not the situation in this case. In this case, the common area was regularly used by TUX Express customers, and as such, it benefited TUX Express because it was the manner that which many customers use for ingress and egress. I want to mention the final case of, as I mentioned in the final case of Timmons, that case is very, very similar to this case. The only distinction is that there was an easement. But the decision was not based on the fact that there was an easement, that the court's ruling was based on the fact there was a duty and that there was a duty existed on behalf of the store to take appropriate steps to make the area reasonably safe.
But wasn't a duty based on the fact that the store had an easement?
But the store had no control over the easement, and that was highlighted by the court's opinion in that case. Store had no responsibility to maintain the easement, no responsibility to do anything. It was just an easement, non-exclusive easement, that other tenants in the complex had to use that common area as a means of ingress and egress.
Is this odd for a decision to discussing an easement if the easement didn't matter to the resolution of the case?
I think the case that is most compelling is the YODER case and the case that I mentioned, which is the Stevens case, because that case there clearly is no easement. If you recall, in the Stevens case, the plaintiff was injured on the 35th Avenue. Well, the defendant had no control at all, no easement, no control practically, legally, or factually over 35th Avenue.
No, but he did have control over his property, which provided the necessity to be on 35th Avenue.
Absolutely, which is exactly what the point I was making a few minutes ago. TUX XPRESS had control over the suite. TUX XPRESS knew customers were regularly using that easement and knew that the bricks were raggedy and potentially loose. There were many things that TUX XPRESS could have done, just like the defendant in the Stevens case could have done, that wouldn't have required them to do anything to the common area itself, such as a written warning to customers, a verbal warning to customers, contacting the owner to demand that appropriate steps be taken so that the risk was eliminated. And those are all things that can be done from the four corners of the premises themselves that have nothing to do with the physical control over the common area. I want to mention the secondary argument that was raised in the answering brief briefly, and that is the argument based upon satisfaction of judgment and collateral estoppel. I'm somewhat hesitant to address the merits of those arguments because the law in Arizona is so clear that this court may only consider the record up through the date that the court entered its ruling granting defendants motion for summary judgment. It may not consider the record after that date in this appeal. Yet the entirety of TUX XPRESS argument is based upon facts and events in the record after the date the court entered its November 3rd, 2015 ruling on summary judgment. And this case is completely different from the Bridgestone case. The Bridgestone case was decided based on the fact that there was a satisfaction of judgment that had been paid, and the court found that along with the splitting of a cause of action, which was done by the plaintiff, precluded the plaintiff from maintaining a second claim against Bridgestone. That's not what happened in this case. I tried my hardest to keep TUX XPRESS in the case. We didn't split our cause of action. We weren't like the plaintiff in the Bridgestone case to try to get two bites at the apple. We did our darndest to try to convince the trial court that TUX XPRESS had a duty so that it would remain in the case and that the trial could be held of all potentially responsible parties. The collateral estoppel issue is also not applicable in this case because, as I pointed out in our reply brief, the joint pretrial statement in the Ava case expressly says that the issue of TUX XPRESS fault is not an issue, and no evidence or argument or statements concerning TUX XPRESS fault can be admitted. So there was no determination that TUX XPRESS was in any way at fault, which is contrary to the Bridgestone case, because in the Bridgestone case, in the first trial against APS, the rental car company, there was actually a determination that Bridgestone was 30% at fault in the product liability portion of the plaintiff's claim.
When all the parties were together in the case, were there cross claims between the defendants for indemnity or contribution?
We tried to get that information in discovery, Your Honor. We're not aware of any such steps that were taken. The record, we're not aware of any. I'm not aware of anything in the record that supports that. Now, I think that there's an elephant in the room that I have to address briefly, but I think it's cured by this court's opinion in the Neal v. Cavina case, and that is the concern that we're trying to double dip, that we're trying to create a windfall. That's not the situation. It was the situation in Bridgestone where the plaintiff actively opposed bringing Bridgestone in as a party in the first case so that it could pursue Bridgestone separately in the second case. That's not what happened here, as I mentioned. And this court in the Neal v. Cavina case expressly acknowledged that there is a possibility that because of the fact that liability is now only several under the uniform, under UCADA, that a plaintiff can obtain a windfall. But if that were to occur in this case, it would be incurred, it would develop for one reason and one reason only. And that's because of the trial strategy undertaken by TUX XPRESS that wanted to get out of the case. If they hadn't wanted to get out of the case, the whole thing would have been litigated at the same time. They are not entitled to a credit for the settlement that was reached between AVA and YODER after that trial. The Neal v. Cavina is squarely on point on that issue, that a party, a non-settling defendant, doesn't get the benefit of a settling defendant's payment to offset what they claim the damages are. And I should also point out, Your Honor, there's nothing in the record that at all supports in any way what the amount of that settlement is. So the argument that the plaintiff has been made whole is completely devoid of any facts, even in that portion of the record that we respectfully submit is not part of the record that's before this court at this time. It's because the issue of duty turns on the relationship between the parties, rather than the geographic boundaries of the land possessor's lease in this case, that the trial court erred in reaching its conclusion that TUX XPRESS had no duty to Mr. Yoder. And I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
May it please the court, John Schneider for the appellee TUX XPRESS. The appellant argues that the issue of duty turns on the relationship of the parties, not on the location of the accident. The appellant also suggests that control over the common area or the lack of control by the tenant is irrelevant. But as the trial court ruled, and it had a 6 or 7 page minute entry, it said that in Arizona, in its survey where you have a common area, they had not seen any situation where a duty is applied to a commercial business such as TUX XPRESS, which is a tenant, and by the lease has no control or ownership over the common area. And instead, on the appeal, ignoring what the trial court emphasized, and the trial court in its minute entry pointed out that I think there were 7 or 9 other states that they pointed out had the similar holding, that is that a tenant doesn't have a duty, and we're not getting into breach and what the standard of care is for breach, but whether there's a duty. And under Markowitz, the appellant would suggest that ownership or control of the common area is no longer relevant. But under Markowitz, the state was acknowledging that it owned or controlled. And you go back to Kaiser, there's nothing under Kaiser versus A.J. Bayless which is rendered overruled or irrelevant in the face of Markowitz. And in Kaiser, it's virtually identical. You had a parking lot fall and a tenant, A.J. Bayless, being sued, and the court held that there was no duty owed to the plaintiff in that case because A.J. Bayless did not own, possess, or control the parking lot. By the same token here, TUX XPRESS had no lease obligation and no control over the common area. And as has already been pointed out, this is not egress, ingress. There were sidewalks. This was a shortcut. And as one of the judges already pointed out, it's a common area. And when you look at the lease, there's no obligation. And in the 17 years that the tenant had been there, TUX XPRESS didn't have any ownership or control.
You know, some of the other tenants actually put plants in the common area, doesn't that indicate that your client has the authority, the control to put plants there? And would that make a difference had they done so?
Well, what other tenants may or may not have done doesn't change my client's lease obligations. We don't know what their lease was with those tenants. So we would argue that what other tenants did is irrelevant. And the plain fact of the lease under TUX Express, it didn't have that right. It didn't have the control. So that doesn't change the analysis here. There's a myriad, it's a multi-tenant shopping center. There's many, many different tenants. There's no indication that they all had the same lease. What we do know is that as it relates to TUX Express, in the area where the appellant fell, it was a common area and it didn't have any obligation to maintain or control it. Going back to the ownership or control, which is the linchpin of all those cases, you look at Markowitz, we discussed that. Kaiser, it talks about ownership or control. Martinez, which was the condominium association, which occupied a status similar to that of a landlord. And the court in Martinez, citing the restatement second of torts, again said, contrary to what appellant is saying here, it's not enough to say you're an invitee. You've got to show that the defendant, much like Bayless in that Kaiser case, had the right to control or own it. And Martinez points out that a possessor of land who leases a part thereof and retains in his own control any part, and then the accident happens upon the part of the land retained in the control, then there's a duty. So we don't get to breach. There is no duty because Martinez, Kaiser, Timmons, they all stand for that proposition. Udi, which appellant says is a good case for them, the parties stipulated that the landlord retained control over the decision over whether to erect a fence, and that was the proximate cause of the injury. There was a three-part decision, and Judges Jacobson and Gerber both emphasized that the right to control or erect a fence was part of their decision. The Clark case says merely because somebody was an invitee doesn't mean that there's a duty. So we have the appellant trying to say that Markowitz changed the law and ignoring that ownership or control over the area in dispute is fundamental to saying that there's a duty. Turning to that other issue, the reason that issue is troubling is that the appellant went to trial subsequent to TUX Express getting summary judgment. And it was presented to the jury that the landlord was 100% responsible for the accident. There was no attempt by anybody to say that TUX Express, and the jury instructions make it clear that the appellant was made whole with the jury verdict. So when appellant's counsel says this is different and not like the appellant or plaintiff's attorney in Bridgestone where they were trying to get two bites of the apple, look, if they had wanted to appeal this case and hold the case in abeyance, that was certainly something that could have been done. But the plaintiff or appellant in this case went forward, presented law and jury instructions to the jury holding that the landlord was 100% responsible. So
was there an argument made in that case that TUX Express was partly responsible?
No. The jury, and that's why we say this is like Bridgestone, because for all intents and purposes, there wasn't any such argument. The jury was instructed the landlord controls and owns this common area, and the plaintiff, in this case the appellant, went to the jury with the opportunity to get made whole. 100% of the damages. There was no fault allocation assigned to the tenant. So this issue, the appellant would suggest nothing that's happened after the briefing of the motions for summary judgment should be relevant. In other words, what they are suggesting is if they were somehow to reverse the case, we should go back down and then appeal it again. But from the standpoint of judicial estoppel, here's what sticks in the appellee's attorney's craw, if you will. They had their chance to go to trial, and they got a great result. The landlord was held responsible. There was no allocation of fault. So how is this in any way different than Bridgestone? It's a procedural thing, form over substance, to say, well, in Bridgestone, when the plaintiff's attorney tried to get a second bite at the apple, there was a satisfaction of judgment. You don't need a satisfaction of judgment to know that the appellant in this case, Mr. Yoder, was made whole in the underlying case. And this is like Bridgestone, regardless of whether there was a satisfaction of judgment or whether they settled the case. So going back to Judge Howe's question, we think it's important that there was no attempt to allocate. And the landlord stood up in closing argument saying, look, if there's a problem with this common area, it's ours. And the jury so found. So why should we, because of the idea that judicial estoppel doesn't matter or nothing that happens after the briefing of the motions for summary judgment should come up in this appeal, should the appellee have to go back down if there was going to be a reversal to then come back up when it's so clear that the Bridgestone case is on point? So that's why we've raised it. Thank you.
Thank you, Your Honor. I think this case really does underscore the challenge in ferreting out the distinction between the existence of a duty in the first place and the facts which constitute a breach of that duty. I mean, that difficulty has been recognized in numerous decisions by not only this court, but also the Arizona Supreme Court. On the issue of duty, it is the relationship of the parties that is dispositive of whether there is a duty exists. Counsel mentions the Martinez case, but the Martinez case is completely in a posit, and the reason is the Martinez case involved a situation where somebody had been shot in a parking lot adjacent to the property owner's business, and the case was first analyzed under Section 315 of the restatement, where the trial court said you don't have a duty to take care of, to be responsible for somebody else making a criminal act. However, at the Court of Appeals level, the court said, well, wait a second. If you retain control under Section 360 of the restatement, well, then you have a duty. So that case doesn't involve the situation where you're talking about a business owner's duty to a business invitee. And that duty is clearly established under the Stevens case, under the Timmons case, and also under the Udi case. I want to mention just briefly, this is not a form over substance situation. I wish I could say that every time we got a favorable jury verdict, that was the end of it. But unfortunately, I've been here too many times to know that that's just not the case. Whether a settlement happens before a jury verdict or after a jury verdict doesn't change the rationale of the Neal v. Covina decision. You take away the risk by settling. And this court says in Neal v. Covina that we're trying to promote settlement among all tortfeasors. TUX XPRESS was included in that. They chose to file a motion for summary judgment. They chose to avoid the time and expense associated with trial, and now we believe that the issue of duty was wrongly decided by the court, and under those circumstances, if this case gets remanded, it will be remanded solely on TUX XPRESS fault and responsibility for the plaintiff's injuries. And for that reason, the reasons I mentioned in my first statement, we request that the court reverse the trial court's decision, remand it with instructions to enter partial summary judgment in favor of YODER on the issue of TUX XPRESS duty. Thank you.
Thank you, counsel. We appreciate your argument today. We will take this matter under advisement and issue a decision in due course. We will stand at recess until the next argument. Thank you.